Yes.
Please, Board. In this appeal, I appear with my name, Mr. Bradley Gardner, Mr. Aeneas, and Mr. Lightbourne for the appellant, Bannerman Town Millars and John Miller's Eleuthera Association, which I'll refer to as the association. And my learned friend, Mr. Rowe, Queen's Counsel, appears with Mrs. Wilson and Ms. Smith for the respondent, Eleuthera Properties. Lord, we understand that the application for leave to appeal made by the Boston Wiley family was struck out this morning and therefore needn't concern the board. There are a large number of bundles, and I hope the board will forgive us for the fact that there are two main authorities bundles and also two supplemental authorities bundles. I'm afraid some of the authorities didn't get reproduced quite correctly, so I apologise for that.
Right.
Lord, there are three issues on this appeal, as the board will have seen from the cases. The first is whether the majority of the Court of Appeal was right to grant a certificate of title to Properties Limited, referred to as EPL, on the basis that it has a good possessory title. And there are two aspects to that. First, that EPL didn't rely on that, and indeed expressly disclaimed reliance on that as a basis for seeking a certificate of title, and therefore it was, we submit, wrong for the Court of Appeal to even consider granting a certificate of title on that basis. And the second is, if that argument is rejected, nonetheless the Court of Appeal's decision was plainly wrong.
The first issue is surely whether EPL have a good documentary title.
That is an issue on which the whole of the Court of Appeal held that EPL did not have a good documentary title. There is a limited cross-appeal at the end of my learned friend's case, a couple of pages, where he says it shouldn't be thought that he's abandoning reliance on documentary title on one basis only, which I submit is plainly wrong in law. But the bulk of the arguments that were presented to Justice Hepburn, which turned on the recitals in the 1959 conveyance, have not been revived in my learned friend's case, and I don't understand myself to have to meet that argument. In case I'm wrong about that, we have dealt with it probably far too great length in our written case. We have explained there why the majority were correct to say that there was no good documentary title.
Which, in other words, because of the perpetuity problem arising out of the will?
Well, the perpetuity problem arising out of the will was one actually relied on before the judge by EPL. They said the gifts in the will were void for perpetuity. At that point, that was contested by the adverse claimants. The judge ruled in favour of EPL on that point. There was an appeal which was rejected by the whole of the Court of Appeal on that point, and that issue has not been revived before your lordships.
But, there is a question, is there not, about whether it was permissible to go back more than 30 years.
Lord, my learned friend has not raised that point in his written case. The lordships have seen how he puts it in his case. Perhaps we can just look at that for a moment. Page 8054 of the bundle. I think your lordships have the written cases separate to the main bundles.
Yes, but they're paginated continuously.
Page 8054, paragraph 143. There is a heading, the judge had in any event been right to say that EPL had a good documentary title. EPL's primary position is that the Court of Appeal was right to hold its entitled certificate on the ground of its possession. It shouldn't be thought to be agreeing with the Court of Appeal that the judge was mistaken to hold the claim to a documentary title. Mm-hmm. And then they say the short point is this: in Ocean Estates and Pindon, Lord Diplock said, as against a defendant whose entry upon the land was made as a trespasser, a plaintiff who can prove any documentary title to the land is entitled to recover possession. And then said that the present case was a fortiori. What seems to be said there is if you have a piece of paper with the word conveyance on it, then you have a documentary title. Well, that's not what Ocean Estates decided at all.
Well, I certainly read that as an adoption of the judge's reasoning generally.
Well, my Lord, we have dealt with the question of the documentary title at length in our written case and made a number of detailed points, none of which are responded to in this written case from EPL. So that's why I say we weren't anticipating to have a debate on those issues here.
Was there a covenant as to title in the 1959 conveyance? There wasn't.
No covenant as to title in the 1959 conveyance.
And,
No
the $1 consideration, was that in the 88 or the 1959?
That was 88.
Yeah.
What happened, my Lord, is that in the period up to 1959, a Florida businessman, Arthur Vining Davis, went around collecting over 400 conveyances from various individuals in relation to the 1,700 acres and some other conveyances in relation to the northern Bowls land. And then in 1959, he entered into the 1959 conveyance to Avon Bay Limited, which related to a large number of parcels of land. And some of those he did give a covenant for title for, and some he did not. And the parcels in the 1959 conveyance which make up the property were among those for which he gave no covenant for title at all. And there is no evidence, no suggestion that Mr. Vining Davis personally ever set foot on the land, ever entered into a tenancy or license with anybody who ever set foot on the land. No evidence that Avon Bay did anything of the kind either. The evidence is that the property was used by a number of individuals both before and after these conveyances, with not being affected in any way by anything done by Arthur Vining Davis or Avon Bay. Then in 1986, a contract is entered into by a group of companies, the South Eleuthera Group, of which Avon Bay was part, to sell a number of valuable properties, including a golf club. And that contract included an option for Eleuthera Properties to buy for $1 plus expenses and taxes a number of other properties which the South Eleuthera Group was hoping to sell to other people. And this was one of them. And the evidence shows that somebody called Chappell agreed to buy the property and then pulled out because of problems with the title. And that was the situation when the 1988 conveyance was entered into, and there was no covenant for title given by Avon Bay when it conveyed the property to Eleuthera Properties.
If the 1959 conveyance does not provide good root of title, that is presumably either because the document itself contains something that casts doubt upon the title being passed, or else because one is entitled to go back to the position before 1959 in order to discover whether in fact there was any title to convey. Now, are you saying that it is common ground, there is common ground on either or possibly both of those 2 points, or that there is perhaps a third point?
Well, I will put it this way, my Lord. We set out in our written case in some detail why the 1959 conveyance wasn't a good route of title and why the whole of the Court of Appeal, every member of the Court of Appeal, was right to so hold. And all my learned friend says in response is what we see here in paragraphs 144 to 146.
Well, perhaps I can inquire of Mr. Rowe whether he is accepting that the 1959 conveyance does not provide a good route of title, and whether he accepts either of the 2 points which I identified a moment ago.
My Lord, the answer is that we rely upon the question of who the parties were who were debating the issue. As we say in our printed case, we do rely upon, I mean, this is, as your lordships will have seen from the structure of our case, our primary submission before the board is defending the judgment of the Court of Appeal concerning the possessory title. But if we need to do so, we do go back and say that as regards the claim in relation to the documentary title, because for reasons that we give in our case, the association itself had no claim, we say, whatsoever to any title, then given that the issue before the court was which of the two parties before it has the better claim to be the owner of the property, then whatever the defects are that one might point at in the 1959 conveyance, nevertheless, the answer to the party that has the better claim to be the owner of the property is EPL, not the association.
So you are saying that the 1959 conveyance provides a good route of title, or that it is simply, although defective, good enough in the light of what you say is the absence of any right on the part of...
My lord, I think if necessary, the former. But on our case, we don't get there because of the difficulties with the association's case.
We do need to know whether you are asserting that the 1959 conveyance provides a good route of title or not, because otherwise Mr. Jordan has no idea of what he's supposed to be dealing with.
Yes. Yes. Well, my lord, then
what is your position?
Yes, the answer.
You are.
But the 1959 conveyance, on its face, doesn't have a covenant of title. And
no.
Doesn't that require inquiry to be made by the court?
My lord, well, that's the point that's made against us, my lord. I see that, yes.
And do you accept it?
What do I accept that it requires?
The fact that it hasn't got a covenant of title requires an investigation to take place.
My lord, I'm not sure I accept that as a proposition of law, that in every case where it does not positively assert a covenant for title, that there needs to be an investigation beyond or behind the terms of the document. Because in my submission, if one's asking the question if one's got into this discussion in terms of is this a good route of title or not, one has got somewhat past the real question, which in my submission is who of the parties before the court has the better claim to be in possession, to be the owner of the property, having received a conveyance from somebody who was entitled to give it. I'm sorry that's not a self-evidently correct answer at the moment, my lord, but that's our position. But as I've said from our case, our primary basis for defending this appeal is that the Court of Appeal in any event was right to say that there was a possessory title. So we don't need to get into arguments about the documentary title.
Right. Well, I think that you had better assume that the 59 Conveyance Act is being relied upon, albeit not as part of Mr. Rowe's primary case in itself.
Well, Lord, my immediate reaction to that is that I had planned my submissions on the basis I wasn't going to have to deal with that. One suggestion that occurs to me is that I might finish half an hour early, and my learned friend would start half an hour and finish. I would then transfer half an hour of my speaking time to my reply. I can hear how my learned friend challenges the unanimous decision of the Court of Appeal on this point and respond in my reply, because I hadn't anticipated having to deal with it.
Yes, well, you're obviously entitled to every possible indulgence in the circumstances.
But very shortly, my Lord, it's, as the conveyancing textbook that I drew attention to in our case says, if you sell property, it's required that you give a covenant for title. It's an essential part of the protection for a purchaser of unregistered land. A gift or a devise in a will is obviously different. Sale, valuable consideration. The purchaser is entitled to a covenant for title. And if there isn't one, that immediately cries out for inquiry. Secondly, after the 1959 conveyance, Avon Bay, the purchaser, went around collecting dozens of additional conveyances, so it had no confidence in its title at all. And third, the uncontested evidence, as I've already said, is that Arthur Vining Davis and Avon Bay never did anything on the land. And the whole point of investigating title to unregistered land is to ensure that there's a long period of undisturbed possession. That's what gives the purchaser his confidence that he's parting with his money for something of value.
Does the fact that this all arises under the Quieting of Titles Act affect that analysis? I'm no difficult with the proposition that good root of title normally arises between vendor and purchaser in an investigation of unregistered land. But here, let's suppose, for example, purely hypothetically, that neither of the possessory claims work. Does the court simply give no certificate of title to anybody and leave the place as unquieted as it was before? Or does it look to see what the least worst title, if any, is, so that it might find that a conveyance, although not good enough to be marketable title under the well-established principles to which you refer, was nonetheless the least worst?
Well, my Lord, we submit that in order to get a title, a possessory title, one has to produce evidence of possession for the limitation period. Otherwise, and I will deal with this in my submissions, but it was said by Lord Walker and Bristol and Lightbourne, I think my Lord Sumption was party to that decision, but otherwise the Quieting Titles Act could be used by land thieves. If all you needed was a short period of possession, and then you could immediately apply for a certificate of title, that would be a very serious flaw in the legislation. And the way that the Quieting Titles Act is structured, we submit, is that the court is required to investigate the title, even if there isn't an adverse claimant before the court, and has to be satisfied that there's a sufficiently good title to justify awarding title to the petitioner. And if there is an adverse claimant, to either the petitioner or the adverse claimant, because the court always has the power to dismiss without awarding a certificate of title to anybody. And if it had been intended that no matter how bad the title was, the court should award title to the petitioner if nobody complained, that power would not be present in the Act. There wouldn't be a power to simply dismiss the petition without more. The court can give the petitioner more time if it thinks the petitioner's evidence is inadequate, and it can dismiss the petition outright.
But if neither of these parties had title, then presumably it's the descendants of the residuary legatee of Miss Miller.
Yes, you would have the documentary
But aren't
title.
they barred by not having intervened after the bringing of the proceedings?
Yes.
So if they're barred, and neither of these parties have title, what then?
They're barred in this petition, but if the petition is dismissed,
Then they can revive.
They can make their own application for a certificate, can they, in subsequent proceedings? You argue the whole thing all over again.
We're now talking about a group of people who have inherited rights from predecessors who inherited from the residuary legatee.
yes.
Well, not from the residuary legatee, presumably from Miss Miller herself.
Residuary
Oh, I thought
legatee was
residuary
called Mr.
legatee was
Farrington,
added.
and he would have inherited, on the basis that the gifts of the land we're concerned with were void for perpetuity,
Yeah.
land would have passed, as my lord suggested, to the residuary legatee, Daniel Farrington, and it would be his ultimate.
Yes, but the former servants and slaves and their descendants are not claiming through him.
Right?
They're claiming on the basis that they believed that they were the people entitled to the land, acted in that belief in exactly the same way they would have done if the gifts had been valid.
Yes.
And as at the 1960s, they had acquired possessory title, had they not?
Precisely what
Yeah.
They did exactly what you would expect them to do if they believed that the gifts were valid. Nobody on the land knew about the rule against perpetuities. It looks as though Arthur Vining Davis's lawyers didn't either, or didn't think it applied here. We're not seeking to re-argue that point. But it's not obvious. It doesn't leap off the page when you read the will that it's void. It looks like a perfectly good gift. People who were using the land, the evidence, the uncontested evidence, was that they believed they were entitled to do it because they fell into the category identified in the will of people to whom it had been left. So they used the land in the way an ordinary occupying owner would. They believed they were entitled to do it. Their belief was that they had collective possession, not separate individual possessions. And therefore, after 20 years, Daniel Farrington and his heirs' title was extinguished. And that's our case. And the fact that Arthur Vining Davis signed a piece of paper and Avon Bay later signed another piece of paper doesn't tell you anything about the title to the land. A documentary title is only as good as the possession of the person from whom you take it. If they're in possession, then they can convey their title to you. If they haven't got possession, the document is worthless.
Well, subject to the point about the relevance of what happened more than 30 years before. That doesn't affect your point about the absence of a covenant of title. But otherwise, it is relevant, isn't it?
Well, my Lord, it is true that if you have a document more than 30 years old, which refers back to yet older documents, you can't, in an open contract, call for the production of those earlier documents under Bahamian law. That's true. But the Quieting Titles Act, as the Court of Appeal rightly said, gives the court the duty of investigating title and the power, if it thinks it appropriate to do so, to look behind the document. And that power was plainly should have been and was exercised by the Court of Appeal here. It's for my learned friend to say why that was wrong. On other aspects of the case, it's for me to persuade the board that the judge and the Court of Appeal were wrong. But on this point, it's my learned friend who has to do that. He hasn't sought to do so in writing. Apparently, he's going to try and do it orally. And I would like to wait and hear how he puts it. And then...
You say there's no covenant of title in the 1959 conveyance, which gives rise to the duty to investigate. And as soon as you investigate, you can see that what was being conveyed was an entitlement under the will, which was void for being against the ruling in perpetuity. And also, in 133 cases, adverse possession not to the entire area, but to particular parts of the area. So,
Lord, not adverse possession, because what the document said is that the person had been occupying a portion.
A portion, that's
The
right.
explanation of that is that by occupying a portion, they were not only claiming as descendants, but descendants who were exercising their rights. And I will explain the significance of that, if I may, when I come to that point in my submission.
Yeah. But as soon as you investigate, you say that the title, the 1959 title, is demonstrably incorrect.
Yes.
Yeah. The duty to investigate arises from, is it only from document, from the actual title itself, or can you have a duty to investigate by virtue of extraneous facts, either before or after the conveyance?
The latter, my Lord.
Yeah.
Any circumstance which casts serious doubt on the title justifies investigation.
Yeah.
Does it make any difference who is asserting this? I mean, if the more than 30-year-old material is relevant to establish the title of somebody who, for example, has a valid claim under the will, let us suppose that it was the residuary legatee's descendants, then one can see that one might want to go back in order to see whether he had a claim more than 30 years old. But if you have a contest between two groups of people, neither of whom can claim under any document more than 30 years old, does the same necessarily apply?
Well, certainly. The mere antiquity of a document cannot give it a power it wouldn't have if it was a bit younger. That can't be a rational basis.
That's not my point. I'm just wondering whether there's a distinction between older material which supports a claim actually being made and older material which is simply relied upon as destroying a right as between two people, neither of whom have any claims under the older document. Do you follow my point?
Well, Lord, if the significance of the 1959 conveyance, so far as the claim by EPL is concerned, is that if Mr. Vining Davis had held possession of the land at the time he made the conveyance, he would have passed that right to possession to Avon Bay, and Avon Bay would then have passed it to EPL. And on that basis, EPL would have the earliest and best right to possession of any party before the court. That's the significance of it. But once it is shown that Arthur Vining Davis did not, in fact, have possession of the land, once that has been investigated and established, the document is a worthless piece of paper and has no significance whatsoever. And its antiquity is neither here nor there in my submission. That is so against anybody. It is so against those individuals who are currently using the land. Your Lordship will have seen reference to a Mr. Charles Roll, in our case? Well, he said in his evidence he was still using the land. He wasn't using it very much, it's true, but he was still using it, as he had been since the 1950s. And if EPL is given a certificate of title, they can kick him off. If they're not given a certificate of title, they can't. And they should only be given a certificate of title if they derive title from somebody who was in possession at some point in the past.
Just before you go on, Mr. Jordan, when I look for the Quieting of Titles Act in my electronic bundle, I get at page 8164 the Quieting of Titles Rules.
Lord, yes, that's one of the errors. I apologise for. It's page
Don't worry,
95.
all I want to know is where I find the Act.
9591.
Thank you.
Could I find the page number for the 1959 conveyance as well, please?
Yes, my learned junior will get that for you. So, my Lord, I was going to explain that I was going to address first the...
Did you say 9591? And if it is, my document says, my screen says there is no page numbered 9591 in this document.
So does mine. I have bundles which stop well before that number.
Right, may I turn my back for a moment to
Yes, of course.
Mr. Solly and find out what's happened?
I'm the same. I think the problem is we don't have the supplementary bundles, which you apologised for at the outset.
No, we were never sent them. No, we weren't sent them electronically. We don't seem to have the supplementary bundles electronically.
Or physically, in fact.
I have a supplemental bundle of authorities with the Quieting of Titles Act at page 9591.
I'd like to intensify my apologies. I'm told by Mr. Solly, my instructing solicitor, that the PDF that I've certainly got with the material in it was sent to the registry a day or two ago. I really
Well, I
apologise.
mean, I use hard copy bundles. You have a hard copy bundle with the supplementary material in it.
I have it, and I'd understood it was sent here yesterday.
Good. I try not to, so if they could possibly send me a memory stick, I'd be most grateful.
Sorry.
I try not to use hard copy bundles, so if somebody could send me a memory stick of the supplementary bundle, I would be most grateful. I got it.
It's not here, but it exists.
I don't have it either. No.
Yes, it does.
Well, we will ensure that that is sorted out overnight, and I do apologise again.
Oh, thank you. Okay.
And in answer to my Lord Sir Ben Stevens' question, it's bundle 3, page 1018.
Thank you very much indeed.
1018.
1018. Perhaps I can take the board through that and for the moment.
Now I've got the Act. Section 7.2, page 9594, concludes by saying the failure of any such person to file or serve a statement of his claim within the time fixed by the respective notices aforesaid shall operate as a bar to such claim.
Yes.
But you say if the proceedings lead to no certificate of title, then he's unbarred, is he? He's unbound.
My submission, yes.
Yes, I see.
Barring it. There is authority in the Bahamas that if you miss for time, you cannot then intervene. And there's also authority that if you miss the time limit and then try and get around it by starting your own separate petition, that might be struck out as an abusive process.
So why?
And then it suggests it's not unbarred.
Right. I'm just looking forward to a possible outcome that nobody here is found to be worthy of having a certificate of title.
Yes.
And all because it never passed out of the residuary bequest in Anne Miller's will, such that the reason why none of these people have any title, apart from how they just haven't got it, is when you analyse it, because those residuary legatees still have it,
Yes.
and yet they're barred.
If the effect of Section 7.2 is that anybody who hasn't put in an adverse claim is permanently barred in all circumstances, even if the court makes an order under Section 17(1)(a, dismissing the application, then that would be the effect.
So the land is what, at the mercy of the first person to turn up with a notice board and a post to drive into the ground, or what?
Well, I mean, one of the cases in the bundle was called Marsden and Miller, where two neighbouring families both made use of a piece of ground. Nobody had any title to it, and they both cooperated perfectly sensibly over many years. And one of them decided they would take the land for themselves, put up a fence and a sign saying this land is mine. The fence was knocked down within 24 hours and everything went back to normal. And then he said he'd been in possession, so he had title, and one can imagine the reaction of the court to that. So it's perfectly possible that if nobody has title, what will go on the land is what has always gone on
Yes,
the land.
but if the way in which the unregistered system works is that possession, if you like, is 9/10 of the law, that is, if you're there and nobody else can persuade the court that they have a better right to possession, then you stay there.
Yes, but there are...
So the first chap who lands on the beach and fences it, if this court concludes that nobody has title, gets it, as I understand it, because nobody can evict him.
There are people, as I said before, using the land at the moment,
Yes,
including Mr. Roll, and they will be able to go on using it.
yes.
So from our point of view, we'd very much prefer it if we got a certificate of title, because then we can manage the land for the benefit of the local people. That's what the association was incorporated for. That's why we're seeking a certificate of title. That's the best outcome for us by far. But the second best outcome is that neither party gets title, because then at least the local people can go on using the land as they always have.
But your submission is that if there is no order made, nobody obtains a title, that the residuary legatee is not barred. But under Section 7.1, the court's got an obligation of actually, if there is an inconsistent claim, to put that person on notice. And so the whole purpose of the legislation is to ensure that all claims are brought together. And wouldn't that suggest that if they haven't made a claim, their claim is also barred, regardless of the...
Yeah, I do see the force of that point, my lord.
Yeah.
Speaking for myself, I don't see how the residuary legatee for his successors can really feature, because on the uncontested evidence about what was happening in the 1960s when the canning factory was open, there were people who'd been in possession for a long time and must have had the effect of ousting the residuary legatee and his successors.
That is our case, my lord.
Well,
But if they subsequently weren't in possession during the relevant limitation period, the fact that they had once been in possession wouldn't make any difference.
Well, providing they're there for more than 20 years, Mr. Farrington's heirs would have been, their title would have been extinguished under the Real Property Limitation Act 1833.
And then it couldn't revive, could it, once it's been ousted by an adverse possessor?
Precisely, my lord. Under the system which has prevailed since 1833. It's been changed in more recent years, but for the best part of 2 centuries, the law was that after the expiry of a limitation period, the title of the person who had a right to recover the land is extinguished. It's gone. It doesn't exist anymore. And that has retrospective effect. They can't claim damages for trespass for the period when they did have a title. The Court of Appeal decided that in the Mount Thurlow case. So, Lord, the way I'd proposed to deal with the matter was to deal first with the Court of Appeal's decision, the majority of the Court of Appeal's decision to award a certificate of title on the basis of possessory title. And then to explain why we say that both Justice Hepburn and the majority of the Court of Appeal were wrong to refuse the association a certificate of title. And, we're not simply asking the court to look at the evidence again for the sake of it. We say there were serious errors of law in the way that the matter was addressed by the judge and the majority. And the correct approach was that taken by Justice of Appeal Adderley in his dissenting judgment. So may I start with the possessory title issue? The board has seen from our written case, and it's not in dispute, that there is a clear and well-established distinction between what Lord Blackburn called constructive possession and what Lord Cairns called actual mechanical possession. If you have taken a conveyance from somebody who was in possession, and you've acquired their title, but you haven't done anything on the land yourself, you have what is called constructive possession. You have the right to possession, and the law will, without reluctance, ascribe possession to you. If, on the other hand...
There is an assertion, a recital of title in the 59 conveyance. Sorry.
If, on the other hand, you don't have that, then you need to have what's called actual possession. And if I may ask the board to see how EPL's case was put on its behalf by Mrs. Wilson in their closing submissions in Bundle 9, electronic page 5324.
Five, 324.
5324, starting at line 17 and going on to the next page at line 22. May I invite the board just to read that?
My understanding is that not only did they not make the case by putting in affidavits, 2 affidavits, but they also denied that they want to make the case. So they puzzlingly asserted that they weren't making the case.
That's the passage I'm showing the court at the
Yeah,
moment. At the moment
indeed.
in the closing submissions. As the board sees on page 5325, letter 10, just after quoting from Justice Slade in Powell and McFarlane, Mrs. Wilson said, "My lady, that does not mean possessory title." And I thought I should stop and make it abundantly clear. The law speaks to, in many cases I've just cited, just but one, my lady, to the fact that a documentary title holder is deemed to be in possession. I believe the Limitations Act makes it very clear that unless he discontinues possession or abandons such possession, he's deemed to be in possession. And that, my lady, then is the claim of the petitioner, but it is the owner of this land by virtue of its conveyance documentary title. The petitioner has never claimed possessory title. That couldn't be clearer, I submit. And the court has seen the judgment of Justice Hepburn. She held that EPL did have a good documentary title and not that it had a possessory title. Then the case goes to the Court of Appeal. The association appeals. There's no respondent's notice saying that the decision should be upheld on the grounds that EPL had a possessory title. But much more significant than the absence of a respondent's notice is the written and oral submissions that were made on behalf of EPL. So may I ask the board to go to volume 11, page 6061.
My bundle 11.
It's volume 10, I do apologise. Volume 10, 606. These are the written submissions of the respondent filed on the 5th of March 2015 on the appeal. And if I can ask the board to turn to page 6075. The appellant had said in ground 5 of its appeal that the learned judge was wrong to accept that the petitioner claimed any title to the property by virtue of a possessory title. And then the response to that by EPL is this: the respondent never claimed a possessory title under the provisions of the Quiet Titles Act. The respondent relied throughout the trial in the court below on its documentary title. The possession relied on by the respondent in the court below and referred to by the learned judge is the possession which is presumed by a title holder and proved through sufficient acts of ownership over the subject land. Again, we submit that could not really be any clearer. And then, if I could ask the board to turn to volume 12 at page 7501.
Well, and proved through sufficient acts of ownership goes a bit beyond just relying on a presumption arising from the conveyance, doesn't it?
Yes, there was a reliance on what's said in Ocean Estates and Pindar, that if you have a documentary title, even the slightest acts will enable you to sue in trespass. But that's not the same as claiming a possessory title.
No, I understand.
And then Lord Bundle 12, page 7501. The start of the transcript of the argument of the appeal. And if I could ask the board to then turn on to page 7513, which, as the board can see, is only a few pages into the start of the opening of the appeal. And on 7514, line 4, commenting on some submission that Mr. Aeneas was making, Justice of Appeal Adderley said, "You're saying it's relevant because it's relevant to the claim of possessory title, you're saying, right?" Does the board have page 7513?
Yep.
Mr. Aeneas, yes, my lord. Justice of Appeal Adderley, as I understand it, you're saying it's relevant to a claim of possessory title by the respondents, but they're not claiming a possessory title as far as I could see, both in their original claim and also what they said before the court last time, and also in their supplemental claim. They do not appear to be making a claim of possessory title. Insofar as it's relevant to that, if that's the only reason you're putting it in, then I agree with what the President is saying, it is irrelevant. Perhaps the respondents can just indicate whether that is so. Ms. Wilson, we are not relying on a possessory title. Justice of Appeal Adderley, so that part of it you can believe. So that comes at an early stage in the oral submissions for the association on the appeal. And then at page 7781, this is in the oral submissions by Mrs. Wilson on behalf of the respondent to the appeal, EPL. And at line 11, she says, "There are several references, my lords, to the fact that the respondents relied on possessory title. The respondent has never said that, and I trust that would be clear in our submissions, and the court would find that he had not relied on possessory title." Page 7807.
Sorry,
7807.
Thank you.
This is Mr. Aeneas in reply. And at the top of the page, he says, "The only possession they claim was constructive possession, which arises as a consequence of the establishment of a paper title. In terms of an adverse possession, which would give rise to a title under the Limitation Act. I understand my learned friends not to be claiming any possession because they cannot. But if I'm to understand otherwise, then I would like an opportunity to reply on that by referring to my submission in 6.61. Justice of Appeal Adderley, I think we understand that respondents have stated clearly that their title is not based on possession, except insofar as possession accrues to a paper title holder." Mr. Aeneas, thank you, my lord, for that clarification. So the oral argument in the Court of Appeal was from the beginning to the end on the basis that the association was not meeting a respondent's notice case of possessory title. The debate was exclusively about documentary title as far as EPL's claim was concerned.
But I mean, there's a fundamental that you have to both allege and prove. And you're saying that they not only didn't allege, but they disavowed alleging. And in the context of, for instance, a criminal trial, the answer to that would be very straightforward and simple. In the context of title to land, there's obviously a public interest in the development of land. There's a public interest in quieting titles to land. And so does the principle apply in exactly the same way? Are there public interests? Do they override the requirement to allege and prove?
Your Lordships will know the correct approach of a judge who considers a case or a point ought to be taken is to invite it to be taken so that submissions can be made on it. And ultimately, although the question of title of land is a matter of public interest, in a quieting titles petition where there is a petitioner and an adverse claimant, it's very much like any ordinary piece of civil litigation. If the Court of Appeal had said, we're minded to give a certificate of title on the basis of possessory title, Mr. Aeneas, you need to deal with that in your submissions, despite the disclaimer of that by EPL, and the association had had a fair opportunity of dealing with the point, then I could have no complaint, but that isn't what happened.
Have you alleged any specific prejudice?
Well, Lord, the prejudice is not being able to put forward our arguments to the Court of Appeal and being faced with a judgment that decides the case against us on a point that was disclaimed. That's manifestly unjust.
Is there any prejudice before the board?
For the board, no. But the prejudice that I face is that my learned friend, Mr. Rowe and his team, say that the board shouldn't interfere with the findings of the Court of Appeal. The findings of the Court of Appeal were reached by a manifestly unjust process which didn't involve hearing both sides.
But the consequence is that if you knock out the EPL's claim on a pleading point, which could be a good point, you leave this title to be agitated forever, potentially. And there's a public duty to try and resolve the issue.
Look, I am not saying that the board cannot look at the evidence and make a decision based on the evidence as to whether EPL went into possession, used the land in the way an occupying owner would be expected to with the intention of doing so for their own benefit exclusively. That isn't the case, and manifestly isn't the case. And the board will see that when we look at the evidence. But what I do strongly object to is my learned friend saying, well, you've already had one chance to argue your case before the Court of Appeal. You shouldn't have another chance. And the board should only interfere with the Court of Appeal on the usual grounds for interfering with a first instance assessment, because that first instance assessment was arrived at in the circumstances that I have shown the board.
Does the status of an objector in proceedings of this kind require the assertion of a competing title, or can you just come along and object?
I hadn't given any consideration to that question. I think the answer is, going back to the Quieting Titles Act,
yes.
Page 959(2), you do have to
You have to be a person who claims any estate or interest in land.
Yeah.
Yep.
any person having dower or a right to dower or an adverse claim or a claim not recognised shall file and serve a statement of claim. So it's not like the Land Registration Act, my lord, where anybody can object to an application. You do have to have a claim of your own to put forward. Lord, in answer to my protests about the way this matter was dealt with by the Court of Appeal, my learned friend has 2 points. First, he refers to a line in a textbook that my learned junior, Mr. Radley Gardner, and I have written, which has nothing to do with this point at all, my submission. Secondly, he refers to a decision of the United States Supreme Court, in which, as far as I can see, what happened is that the Attorney General made some submissions on what the law should be, which the Supreme Court accepted. Again, that really has nothing to do with the point that I'm making. So, my Lord, putting that to one side and then looking at the material itself.
What do you propose that we should do about the point you have made? That is, this was not a claim. They did not make this claim. They disavowed this claim. What are you proposing that we should do?
Well, my Lord,
Look at the evidence or strike it out or what?
I imagine that my learned friend would invite the board to look at the evidence and make its own assessment if the board is inclined to accept my submission that the Court of Appeal held this unfair.
Plainly, whatever your lordships make of my learned friend's procedural point, our submission would be that it would be not in the public interest for the matter to be left decided effectively on a pleading point. And so if your lordships were against us on that, but were amenable to be persuaded that on the merits, the decision that the Court of Appeal made about possession was the right one, then that would be the right disposition of this appeal, in my submission.
On that basis, I better address the evidence. So, Lord, as far as the principles that are applicable to establishing possession are concerned, they're very well established and very well known, and I suspect it's unnecessary for me to rehearse them. They're stated very clearly in J.A. Pye and Graham by the House of Lords. What I do want to emphasise is 3 points, none of which the Court of Appeal paid any attention to. The first is that both elements, both the physical element of possession and the mental element of possession, must be established for there to be possession. To make that good, can I take the board to the second volume of the authorities, page 8953. 8953, tab 54. Case called Simpson and Fergus, decided by the Court of Appeal in 1999. It was an unusual case because it was one of those rare cases where neither party had any documentary title to the land in issue. There aren't many of those. Normally these disputes are between somebody who has documentary title and somebody who doesn't. The land in question was a service road at the rear of a terrace of houses. On page 400 of the law report, page 8955 of the bundle, Lord Justice Robert Walker summarises the facts by reading from the judgment of the circuit judge. That's about a third of the way down that page. It says the circuit judge put it like this. Circuit judge put it like this, and he was essentially repeating findings made by the district judge who'd heard and seen the witnesses. Nobody, it would seem, has paper title to the lane. That notwithstanding, Mr. Humphreys was completely unabashed and embarked on a series of audacious acts of annexation. Within a year of the purchase of his property, he caused to be marked out on the road with reflective strips the 4 parking spaces on the land now edge red. He erected notices saying that these spaces were for blue haze only. He put up a notice saying private lane, no unauthorised parking. He chased off anybody who had the temerity to park in the lane, either by verbally telling them to go if he caught them in the act or by sticking a notice on their cars if he did not. And then it said that Mrs. Simpson, when she took over, carried on in much the same way. And then over the page on page 401, Justice Robert Walker summarises for law. May I invite the board to read page 401 down until the last paragraph? So the basis on which the district judge decided the claim in favour of Mrs. Simpson was that she'd done everything possible to assert an intention to possess the spaces, and indeed that was plainly the case. She had done everything she could possibly have done to say these spaces are mine. And then on page 402, the report 8957 of the bundle, in the last paragraph, Lord Justice Robert Walker explains why that was a wrong approach. And he says, in the second sentence, possession is a legal concept which depends on the performance of overt acts and not on intention, although intention is no doubt a necessary ingredient in the concept of adverse possession. It may or may not be sufficient in international law to annex an uninhabitable rock by planting a flag on it. Maybe that is what the circuit judge had in mind when he spoke to Mr. Humphreys raising his standard. To establish exclusive possession under English law requires much more than a declaration of intention, however plain that declaration is. Actual occupation and enclosure by fencing is the clearest and perhaps the most classic way of establishing exclusive possession, though even enclosure is not invariably enough. See Marsden and Miller. That was the case I mentioned about the neighbours, where a neighbour put the fence up and then it was taken down. It may well not have been feasible for Mrs. Simpson or Mr. Humphreys before her to have fenced off the parking spaces, though conceivably it might have been possible to do so with some form of movable barrier, movable post, chain or whatever. Had either Mr. Humphreys or Mrs. Simpson attempted to do that, matters might have come to a head much sooner. But to my mind, it is not correct, and it would indeed be a serious heresy to say that because it's difficult or even impossible actually to take physical possession of part of a reasonably busy service road, that simply for that reason some lower test should be imposed in deciding the issue of exclusive possession. That's the first point. It's not enough to intend to possess, to put up signs saying this land is mine, or manifest your intention to control the land. You actually have to use it and control it. You can fence it off, you can farm it, you can build on it, you can quarry on it.
Well, it does depend upon it depends upon the circumstances, depends on what the nature of the land is. But do the circumstances include the identity of the person and the nature of the person who is allegedly possessing? For instance, a farmer might possess in one way and a property developer might possess in a different way.
Yes. A property developer would possess by building houses on the land, and a farmer by ploughing it up and cultivating it. They would both be ways in which an occupying owner could use the land.
And would a property developer mark out his land, first of all, while he was getting his ducks in a row?
That would be enough to take possession. It would be a preliminary to taking possession rather than actually taking of possession. But, my Lord, to answer precisely the point that the Lord's asking, may I go to tab 50, page 8840, case of Powell and McFarlane, where an answer is given at this point. Justice Slade, at page 8858. This is my second point. At the bottom of page 8858, Mr. Justice Slade says at number 3 in his summary of basic principles, factual possession signifies an appropriate degree of physical control. It must be a single, and that should be exclusive, that's a typo, single and exclusive possession, though there can be a single possession exercised by or behalf of several persons jointly. Thus, an owner of land and a person intruding on the land without his consent cannot be in possession of the land at the same time. The question what acts constitute a sufficient degree of exclusive physical control must depend on the circumstances, in particular the nature of the land and the manner in which that land is commonly used or enjoyed. In the case of open land,
You'd add in the words commonly used or enjoyed by the individual who's claiming possession.
Lord, no, that's what he goes on to say in a few lines down. He says, after saying it's impossible to secure every part of the boundary, what is a sufficient degree of sole possession and user must be measured according to an objective standard, related no doubt to the nature and situation of the land involved, but not subject to variation according to the resources or status of the claimants. So that's the key point. You look at the land and say, in what way is this land commonly used or enjoyed? Not by a particular type of person, but having regard to the nature of the land. And land of the kind we are concerned with could be, and had been for decades, enjoyed by farming it and also by quarrying it. There was evidence of both uses. And it could, of course, be used and enjoyed by clearing it and building on it. But simply clearing some shrubbery around the edges is manifestly insufficient. The correct approach in our submission is, if one looks further down the page, at the end of this section of Justice Slade's principle, the last sentence, he says, "I think that what must be shown as constituting factual possession is that the alleged possessor has been dealing with the land in question as an occupying owner might have been expected to deal with it, and that no one else has done so." An occupying owner, not somebody who intends to take up occupation in the future. Lord, just to make that point good by reference to one more authority, in volume 1 of the authorities bundle, page 8309, tab 18.
And the page number is?
It's 8309 is the start of the case, bundle 1, tab 18. This was a much more familiar type of adverse possession dispute where there was a registered proprietor, the council, and a would-be squatter, Mr. Chambers. And page 830, start of the case. And the trial judge held that Mr. Chambers hadn't been in adverse possession. He appealed, and the Court of Appeal said the judge had made a number of errors, both of principle and the way he dealt with the evidence, and set his decision aside and remitted it for a retrial. And on page 8322, in the judgment of Lord Justice Lewison, if I could ask the board just to read paragraphs 48 and 49 of his judgment. So Lord Justice Lewison criticises the judge for not asking the right question. The right question is how an occupying owner might have been expected to use the land, for what use is the land suitable? And he suggested the way to do that was to look at the past, although accepting the point made by my Lord Sir Ben Stevens, it would also be appropriate to look at how the land might be used in a different way if it was suitable for that use. But you have to ask the question. And the Court of Appeal in the present case did not ask that question. They could have only answered it in one way. So, Lord, those are the principles of law. And I'd now like to turn to the evidence. If we could go to the Statement of Facts and Issues, page 7890.
There's a point that interests me in relation to the legal principle, and that is that if you have a number of people possessing land, there has to be a single possession. And you can have single possession on behalf of a number of different people if you have either an agreement between them or a joint intention between them. And so in order for an adverse title to be achieved, there would have to be not only actual possession, but it's got to be a single possession, and the single possession in this case has got to be based upon a joint intention. There wasn't any agreement. There has to be a joint intention. Is that correct?
Lord, may I come back to that when I deal with our appeal
Yeah.
against the refusal of the court to give us a certificate of title?
Yes.
That aspect of the case isn't relevant to EPL, which is a
Yeah.
single entity.
Yeah. Yeah.
Joint intention.
Right.
My short answer, my Lord, is that the intention that is needed to give rise to a single possession by more than one individual is an intention to use the land on the basis that you are jointly entitled to it. That is the relevant intention, whether there is a paper title or is not a paper title. If one imagines what would have happened if Anne Miller had left the land by a valid devise in her will to her servants and freed slaves residing on Millars at the date of her death, and there had been a number of them, and they had used the land, and you had interviewed them and said, what is the intention with which you're using the land? They would have said, well, I'm entitled to use it jointly with the other descendants because Anne Miller left it to us in her will. And that is the intention that is required. They intend to use the land by virtue of their joint right to it, which was a right that they believed was given to them by the will. That's all that's required. So that is, in a nutshell, what I will be saying about the mental element of possession in a situation like this.
But the joint right in the will was void for perpetuity.
But in the example I've just given, it wouldn't have been.
I know, but the example you've given, you relied upon the will. And
Well, I'm perhaps I can leave it till
yes.
I get to that point in my case, but one of the main functions of adverse possession in relation to unregistered land is to cure defective assurances. People act on the basis they're entitled to land, but the document is defective in some way. After the expiry of a limitation period, their expectations are vindicated by the law, and it ought to be applied in a situation like this in my submission. But perhaps I can develop that when I come to that part of our case. So, Lord, I was asking the board to go to the Statement of Facts and Issues at page 7890, where there is an agreed summary of the evidence that was relied on. And taking it chronologically, if I may, the first in time to have anything to do with the property is Mr. Coakley, Mr. Stafford Coakley. And the board will see at paragraph 37.2 that he gave evidence that he carried out a survey in 1988. This doesn't say when it took place, but he did say in his oral evidence, but it was in January, and the plan that he produced is dated March. So this was many months before the conveyance, the 1988 conveyance by Avon Bay to EPL. It's a survey being done by somebody proposing to acquire an interest in land, and a pre-acquisition survey manifestly can't constitute a taking of possession. That would be absurd. What one can see from the Statement of Facts and Issues is that in the course of carrying out his survey, he reopened the boundary lines around the property, and he explained in his evidence what that meant. There are boundary markers around the outside of the property, and they get overgrown with vegetation, and he and his team cleared away the vegetation, so you had a line of sight between the boundary markers. That's what clearing the boundary lines, opening the boundary lines means. And he also said he cut a track road as part of doing the survey, and in his witness statement he said this was to avoid having to walk around the perimeter of the land to get from one side to the next to speed things up. That's page 687, paragraph 4, but I won't turn it up if that's acceptable. One can also see from the Statement of Facts and Issues that at the same time that Mr. Coakley was doing this survey, another surveyor was also doing a survey at the same time, and they produced a separate plan. So
where is the other surveyor in the Statement of Facts and Issues?
it's in his oral evidence, Mr. Coakley acknowledged that Richland Investments Limited survey relied upon by TMCL in support of the 1995 petition EL 505 was carried out at the same time as the 1988 survey and possibly before. And the evidence about that was that a Mr. Godfrey Humes had been responsible for that survey, instructed by the McKinney family. And the reference to that in the bundle is page 1002, paragraph 21, and also page 7890. So just looking at this survey by itself, Mr. Coakley and his team go to the property. Mr. Humes and his team are there at the same time. They're both carrying out a survey. Mr. Coakley clears some vegetation away from the outside of the property, cuts a track road through the vegetation on part of the property to get from one side or the other. We submit that plainly can't constitute a taking of possession. The next witness who talked about things on the land is summarised, his evidence is summarised at paragraph 37.3. This was Mr. Cranston Patram. And he worked for EPL between 1994 and 2004. And he said he oversaw the reopening and clearing of the boundary lines of the property twice a year by cutting the boundary lines and making sure all the markers were visible. He said there were signs at the boundaries saying Eleuthera Properties Limited, though the paint was flaking off them and one could not read them properly. He said he placed new signs on the property saying it was private property and to warn of the prosecution of trespass. These stayed up, he said, until 1996 or 1997 for 2 or 3 years. But thereafter, oftentimes these signs were removed, and this was reported to the police. When he visited the property, he said he looked to see if there were any access roads, and as he saw none, he saw no activity. He concluded nothing was going on. He didn't enter the property and was only really acquainted with its boundaries. And there was some evidence that he was asked to leave on occasion. And in our submission, that plainly could not constitute possession of the property. It was not using the land in the way an occupying owner would use it. He didn't put up a fence. If Eleuthera Properties had put up a fence, there would have no doubt been an almighty row. But they didn't. And simply cutting away the vegetation around the boundary markers and putting up some signs, which don't even last more than 2 or 3 years, is plainly not enough, we submit, to constitute taking possession. As far as reporting things to the police is concerned, there is in the bundle a statement by a policeman, which, since the President referred to it, I ought to show the board. It's in bundle 3 at page 1098.
This is a different Mr. Raleigh, presumably.
Yeah, there are many Mr. Rolls indeed. This one is, I think he's called Kipling Roll, a police sergeant, and he says he witnessed Mr. Patram, land surveyor, place private property signs on the property known as Chapel or Millars Estate in 2000. So we don't dispute that signs were put up. Mr. Patram said they were often taken away. No doubt that would constitute theft, so the police properly informed. But we say that has nothing to do with the question of possession of 2,000 acres of land. As far as cutting vegetation away around the boundary lines is concerned, a fence is an act of possession because it says, this is my property and you can't come on it. The fence physically prevents people from coming on it. Fencing isn't invariably enough, but it is, at any rate, a clear physical use of the land in a way that marks out its exclusivity in the way that simply cutting a boundary line plainly is not. There is a case that we've referred to on this point that I would like to just show the board in bundle 2 of the authorities at page 8913, tab 52, 8913.
This opens up the middle of a case. What's the name of the case?
So this case is called SS Global and Sava.
Oh, yes.
It's
Yeah.
This is the decision of Mr. Peter Lever, QC, sitting as a Deputy High Court Judge. His decision was upheld by the Court of Appeal. And at paragraph 61, he says, there are many acts which are capable of demonstrating that a person who's not the owner of land is dealing with the land as an occupying owner might have been expected to deal with it. There are many acts which are capable of demonstrating that a dispossessed owner is exercising his rights of ownership or possession of the land. Inevitably, the reported cases depend upon their own particular facts. There are, however, some acts which are by their very nature such as to demonstrate factual possession. And then at paragraph 66 on page 8915, he says, equally, the mere maintenance of existing boundary features such as a fence or a ditch or a hedge is not an act which unequivocally asserts exclusive control over land. That is important in a case such as the present, where the ditches and hedges that border the fields on the disputed land were all features that were present when Mr. Sava moved on to the disputed land. And we adopt that. We say that is a correct statement of principle.
Presumably that's a statement, a factual conclusion rather than a legal principle.
Lord, it's saying that certainly absent very special circumstances, if you come to land and there are boundary features and you keep them in good order, that is not enough to manifest an intention to possess, or let alone to constitute factual possession. My learned friend in his case says it's not helpful to look at factual situations in other cases, but in my submission, this is an area of the law where consistency is important, and insofar as one can extract principles as to acts which generally will or generally will not be regarded as sufficient, that is an appropriate use of authority.
Well, the
What's
principle
wrong?
is that one looks at the usual or appropriate use for that particular piece of land.
Yes.
And the cases are showing us how that principle is applied in particular circumstances. So there's some force in Mr. Rowe's point.
I shan't take it any further, my lord.
What's wrong with a sign saying private? I mean, maintaining a fence is one thing. A fence doesn't necessarily speak, but maintaining a sign saying this is private property belonging to Eleuthera Properties Limited. I'm not sure what these signs did say, but I think the evidence suggests that some of them referred to the respondents by name. But why is that not what Mr. Lever calls an unequivocal assertion of exclusive control over land?
Well, because it's no more than what was done in the case about the service roadway, Simpson and Fergus. It's no more than an assertion of an intention. It's not factual possession. If Eleuthera Properties had been farming the land and had put up signs, then that would have manifested their intention to possess, and coupled with their factual possession, that would have been enough. I accept that a sign saying private property is saying, this is my land, keep off, although if the signs are removed, that takes away their force, obviously. But that's all they are. It's not factual possession. It's not
Taking
using.
possession, it's the doing of it rather than what happens to what you've done that matters, isn't it?
Well, my lord, it's what you do on the land that matters.
Yes.
And simply saying, this is my land, as happened in Simpson Fergus, is not enough.
Well, it would make it extremely difficult if you had a barren desert, wouldn't it?
Lord, you can always put up a fence, which the judges have said is, generally speaking, a pretty clear act of possession.
Somewhat impractical when it's a rather long fence.
But then in Simpson and Fergus, it was said the fact that it may be difficult isn't a reason not to. Anyway, there is no particular difficulty in fencing. It's a big piece of land, so you need a big fence. But there's nothing particularly impractical about putting up a fence around it. Certainly there's no evidence there was any difficulty about putting a fence up. Well, the next thing that happened is that in 2000, Mr. Coakley flew over the land in an aeroplane, somebody who took some photographs of it. That obviously is not taking possession. Then we have the evidence of Mr. Fernanda, which is summarised at paragraph 37.4.
Isn't that evidence only relevant to the issue as to whether they knew that somebody else was there?
Yes.
Yes.
Yeah. And they didn't?
Yes, they said they didn't see
Yeah.
many signs of occupation, although there were some bits and pieces. But not much.
I mean, all this was being deployed in answer to the association's possession claim, as I understand it, because they weren't themselves advancing a possession claim other than on the basis of the conveyance. Yeah.
This evidence was called to say there was no substantial use of the property from 1988 to 2010. Although, by the time Mr. Fernanda came on the scene in 2006, there was some activity. He says, as one can see in paragraph 37.4, that he was employed to monitor the property and clear vegetation from the boundary lines. He first came there in 2006 and observed that there was farming on the property in 3 cleared areas. He said he'd informed these farmers that they were farming land belonging to the respondent. They voiced no objection to this. He did not say he asked them to leave or tried to charge them rent, and there was no evidence adduced that he was asked to leave. One of those individuals who gave evidence, Mr. Martin, said he had seen Mr. Fernanda, but during their brief conversation, Mr. Fernanda did not say he was employed by the respondent. I did not suggest that Mr. Martin was trespassing. Mr. Martin added that had Mr. Fernanda done so, there's no way that he, Mr. Martin, would have acknowledged that the property was owned by the respondent, because he was sure he was entitled to be on the land, and that wasn't challenged in cross-examination. And Mr. Fernanda said that between 2006 and 2009, other farms were cleared, and he prepared a plan showing where they were. You should see that plan, which is in bundle 2 at page 680. So the key from 1 to 9, 1 and 2 both say cleared name M. Mackey, and one can see that Mr. Mackey was up on the northern Bowls land where the 1 and 2 are. And then 3 says building UC, which Mr. Fernanda said meant under construction. And then 4, cultivation, no name. 5, cultivation J. Wilson. 6, cultivation H. Forbes. 7, cultivation question mark. 8, building under construction. 9, cultivation B. Martin. So one can see that by the time this plan was prepared, there was quite a lot going on the land. And what's significant about that is that, subject to something that happened in 2009, 2006, 2007, 2008, first part of 2009, Eleuthera Properties did absolutely nothing about these people who were carrying on activities on the land, which were the sort of activities that an occupying owner would be expected to carry on. Farming and building.
Sorry, what was the date of the plan again?
I was just trying to make it out. Can I come back to my lord on that question? What happened in 2009, in August 2009, is that possession proceedings were brought against Manasseh Mackey, who the court has seen was up on the northern Bowls land. And I just need to show the court the evidence about that. We start in bundle 1 at page 20.
You say 20?
Yes, page 20. Paragraph 6, this is the affidavit sworn by Mr. Wilson, who is the chairman and director of EPL. And in paragraph 6 he said, in May of 2009, Eleuthera Properties had its attorney write to Benjamin Manasseh Mackey demanding that he vacate its land. Paragraph 7, on 6th August 2009, Eleuthera Properties Limited commenced action number 1204 on its common law side of the Supreme Court to compel the said Benjamin Manasseh Mackey to vacate its land. And that's all he says about that. He also
what's the
says...
result of the action?
Sorry?
What is the result of that litigation?
Mr. Mackey, it seems, vacated. I will show the court such evidence as there is on the subject.
Voluntarily, or did the court tell him to?
Voluntarily, I think. I'll show the court what evidence there is. It's not much. Bundle 5, page 2238. My learned junior has blown up Mr. Martin's plan, and it seems to be 2000 and the blurred 9, 2009. I'll be corrected if I've got that wrong. So, Lord,
Between 2009 and 2010, you say they did nothing about these people.
I said that between 2006, which is when Mr. Fernanda came on the scene,
Yes.
and the claim that was made against Manasar Mackie, who was in the Northern Bowlsland, nothing was done about Mr. Wilson, Mr. Forbes, or the other people. Something was done in relation to Mr. Manasar Mackie, as we've seen from Mr. Wilson's affidavit, and page 5, bundle 5, page 2238 is his evidence in chief, lines 5 to 16. He was asked in chief about this. It says here, 2009, Benjamin Manasar Mackie cleared approximately 4 acres of land. What has become of Benjamin Manasar Mackie? The matter, you know, he disappeared. Was any action, as far as you know, was any action taken by the petitioner against him? I don't remember the details. As far as you know, what has become of him? You said he has disappeared. Well, the land, the issue of his continuing to challenge our ownership of the land is no longer an issue, as far as I'm aware. Yes.
He disappeared.
Yes. And then page 2712.
Yeah. That simply, he ceased to be a problem.
2712, a little bit more evidence is given by Mr. Wilson. Mr. Wilson couldn't complete his evidence the first time he was called, so he came back. This is his second tranche of evidence on page 2712. The cross-examination.
So what was the first page, the page we just left?
First page is 2238. And then 2712, it looks as though perhaps Mr. Wilson had refreshed his memory in some way.
Is this cross-examination?
Yes, this is cross-examination by my learner friend, Mr. Lightbourne. And Mr. Lightbourne at line 19 draws attention to paragraph 10 of the witness statement and says, now, how were you made aware of that act of trespass, as you call it? That would have been brought to my attention probably by Thomas Sands, his father having passed away, or it might have been by Ricardo Fernando, or it might have been the attorneys, but I was told. You never went there to examine it. No, and I was advised that the gentleman vacated the property on short notice. So it seems as though he'd remembered a bit more about what had happened by then, and Mr. Manasar Mackie is served with proceedings and disappears. I think the only other evidence about Mr. Manasar Mackie is that he became ill and subsequently died. That's in bundle 7 at page 4084, but perhaps it's not necessary to turn that up. Page 4084 anyway. That's Mr. Benjamin Martin in cross-examination by Mr. Smith said that Manasar Mackie had become ill and had died.
And it's clear that that happened after he had actually left the land, is it?
He became ill and died.
Yes. So we're looking at bundle 7, page what?
Page 4084. Line 16, when last you saw him on the farm on there, he got ill and died. He was only buried last week, says the person asking the question. He didn't farm there for quite a bit, for about a year, maybe more.
So when was this cross-examination?
This is in May 2013.
And just remind me, when were the proceedings commenced against him?
In 2009, a few months before this petition was filed.
Probably he died sometime after he left.
Yes, he died, it seems, in 2013. Perhaps he was ill at the time, perhaps he wasn't ill at the time, perhaps he didn't feel he had the resources, financial or otherwise, to take on Eleuthera properties. We don't know.
And the area of land was in the Northern Bold Track, is that right? Yeah.
The board has seen Mr. Fernandez's plan showing exactly where Mr. Mackey was. And that, we submit, is quite insufficient to put EPL in possession. In any event, it only occurred a few months before the petition was filed.
I mean, your claim in respect to the Northern Bowls track is much weaker on any view, isn't it?
Yes. It is, my lord.
Yeah.
So, Lord, that is the evidence.
Just remind me that the clearing the boundary and putting up the notices included the Northern Bowls Track.
Yes.
Yeah.
The boundaries of the property, my lord, the board has seen plans of the property attached to our case, which I hope are helpful in illustrating it. We've also put together a small clip of plans, which perhaps would be an appropriate point to hand up, just because they're easier to see than the ones in the bundle. So the first page, page 1 of this clip, is the plan that Mr. Coakley had prepared after the survey, which he did in January 1988. And if the board looks in the bottom left-hand corner, one sees the date March 1988. So that's when this was prepared. And it shows the property. And one can see on this very clearly that the property is carved out of various parcels of land that are shown with dashed broken lines. So, for example, if one starts right at the bottom of the page, one sees the words land originally granted to Robert, Ann and George Miller. And then above that it says grant K38 John MacDonald. Well, that is an original Crown grant, and one can see that the left-hand part of that extends beyond the black line that runs up and down the page. That thick black line is what the witnesses called the Queen's Highway, the road built by the government that runs from north to south and forms the western boundary of the majority of the property. And then above that one can see grant K24J Miller, 400 acres. To the right of that, grant G52, and so on. So there are all these different original Crown grants. And then the top of the page, where one sees the big pond, one sees the words formerly William A. Bowles, and also on the east side of the highway, formerly William A. Bowles. And then to the right of that is J.W. Miller Grant Panda Tract. And on the far east, one sees the sea, so the eastern boundary of the land is marked by the sea. The southern boundary, the evidence was there was a loose rock wall. The western boundary, apart from the road, the western boundary of the Northern Bowls Tract is also water. And the northern boundary, certainly in the Bowls Tract part to the west of the road, there was a loose wall made of rock as well. And one sees above the plan the words grant G34 James Kelly. That's for land north of the property. So that's the layout of the property. The next page is a rather poor copy, I'm afraid, but the best I could make.
What marks the southern boundary of the Northern Bowls Tract?
Well, it runs through the middle of a pond in part, so
Doesn't it cross the bottom of the pond? There's a line which I thought, from comparison of this with your Appendix 1, I thought this line, which goes along the bottom of the pond, is the southern boundary of the Northern Bowls Tract. And
Yes.
what I'm asking is that another loose rock wall or a path or
No,
what?
I don't recall there being any evidence about any physical feature running along that boundary.
It's just a boundary which exists but is unmarked.
That is my understanding of the evidence. My learned friend is holding, I believe, a photograph.
At some point, if it's convenient, we've got copies of the 2000 flyover that was referred to in the evidence. I don't think it's actually formally in the record, but I understand it was on display in the court throughout the proceedings below. So if that's convenient at some stage, we might make copies of that available, because it shows, as you probably see from that distance, the land from the air with the boundaries plotted onto it.
Yes. And what marks on the ground the southern boundary of the Northern Bowls Tract?
My lord, I think the answer is, and I think that the picture doesn't lead me to give any different answer from the one you've had from my learned friend. I don't think that
It's just an unmarked boundary.
anything on the ground marked there.
Yes.
Oh, I'm grateful. So, Lord, the second page of the clip is a copy of a plan that was in evidence. It's not a great copy. I have got here the copy that was provided when it was produced in evidence, which is a little bit clearer. It's quite a lot clearer because you can actually read it. I will perhaps try and make better copies of this overnight, if I may, rather than taking the court to that now. And then the remainder of the clip is the entry from the Gazette, which I thought was easier to read if it was blown up a bit. I'll come back to that tomorrow morning, if I may.
Just so I fully understand the areas of land, there's 1,700 acres, which is one particular area. Then there's the Northern Bowl Tract. And if you deduct the 1,700 from the 2,806, 2,086, you get a balance of 386 acres. But that's not the area of the Northern Bowl Tract, is it?
Lord, there was at one point when I was reading the evidence when I understood how the numbers all added up.
Right.
I can remind myself of that and provide your Lordship with a reconciliation. I think Mr. Coakley explained it in his evidence. He showed how there are various offsets for bits of road that he allowed for in his calculations.
Right.
I think that's how it works.
But the whole of the Northern Bowl Tract is part of the application and was part of Gift 3 in the will, is that right?
Yes, the Northern Bowls Tract was the subject of Gift 3 in the will, where it was divided into three sections, 100 acres, 50 acres.
Yeah.
It was described in the will. No doubt that wasn't an exact measurement.
The Northern Bowls Tract is the whole of Gift 3, isn't it?
Yes.
Whereas Gift 2 is our property, 1,700 acres, plus the land to the south of the Northern Bowls Tract, as I understand it.
It's, for example, if you look at the, if one looks at the Grant G25 William Sands or Grant K24 J Miller on this plan here. So if you go down if one goes down from William Bowls, 500 acres, immediately below that is William Sands, 400 acres.
Yes.
And we know that that was conveyed to Robert Millar, who was Anne Millar's brother, and then ended up being owned by Anne Millar.
Yes.
And the whole of that formed part of Gift 2, as did the whole of the J. Miller tract, K24 below. But when Mr. Vining Davis was collecting up his conveyances, he focused on the land on the west of where the highway was going to be built. The east of where the highway was going to be built. He didn't attempt to get any title in respect of the land to the west of where the highway was going to be built. So he took conveyances of part of the land in Gift 2, but not all of it. The plan that we put in Appendix 2, I think it was, to our case, on page 7950, That shows the whole of the Gift 2 land, which includes the 1,700 acres, which is all of the Gift 2 land on the east side of the highway.
And is it right that land coloured pink on your Appendix 2 is precisely the land which was being claimed by the claimants in the 1995 petition?
Tom and Millars Corporation.
Yes.
Yes, it is. So, Lord, if I can then go to...
Well, if they were co-tenants of the what I call the 1995 lands, their assignment or their purported conveyance of part of the 1995 lands to was invalid, presumably. Yeah. Yeah. And so as soon as you put somebody on inquiry as to the 1959 conveyance, you run into that problem as well.
That's the point made by Lord Scott in Higgs and Lachelle.
Who currently owns the land to the south of the Northern Bowls Tract?
As far as I'm aware, there's no... is there a... Perhaps I could allow Mr. Inias to answer that question.
The land to the south of the Bowls tract is claimed by the association,
And nobody
having
disputes
acquired it from the Tom and Miller Corporation.
that. And is it right that nobody disputes the association's ownership of the land to the south of the Northern Bowls Tract?
That's correct, my lord.
But I think it's right to say there's no certificate of title.
There's no certificate of title.
But, was that my Lord's question about that area of land? Not the land to the south of the property, which is called...
I was asking about the land to the south of the Northern Bowls Tract, i.e. on the left-hand side of the road. And the answer is that nobody disputes that the association owns that.
So far as we're aware.
Lord,
so we're told.
if I can then go to the judgments of the Court of Appeal, please, in bundle 12 at page 7413.
Paragraph?
Paragraph 96, this is in the judgment of the President. And she's summarising here the evidence which the trial judge had accepted from Mr. Coakley. And then in paragraph 97 over the page, she refers to the signs that Mr. Patram put up. And she refers to that letter from the policeman, which I've shown the board. Paragraph 98, she says the strongest acts of possession are those of the respondent in relation to trespassers, plural, found in the evidence of Mr. Patram. Well, he didn't give any evidence about trespassers. And then she says, for indeed the respondent has successfully asserted its possession of the land against another in a previous action before the courts. And then she refers to something that Mrs. Wilson said in the course of her submissions about Manasar Maki. And I have shown the board what I believe to be all of the evidence relating to Mr. Manasar Maki. No doubt if I've missed anything important, my learned friend Mr. Rowe will pick that up in his submissions. So that was the material that the President thought put Eleuthera Properties Limited in possession of this property for the limitation period. And she says at the top of page 7415 this, i.e. the action taken against Mr. Mackey, and the other acts described in the evidence of Messrs. Coakley, Williams and Fernando, which I've taken the board to, provide a clear case on the part of the respondent of factual possession of the property and the intention to possess the same to the exclusion of all others. And then to support that view, she refers to the decision in Ocean Estates and Pindar, which he says clearly demonstrates that the aforementioned acts were sufficient to establish possession. Therein they opined the plaintiff has, by the use of the land by their predecessors from 1941 to 1946, by their architect's inspection in 1957, and the surveys from 1959 to 1960, established sufficient possession to bring an action for trespass to land and to negative any intention on their part to abandon possession. And in our submission, she has misunderstood the decision in Ocean Estates and Pindar. And I will try and explain why. If I can start by looking at two cases that are referred to in the submissions in Ocean Estates and Pindar, and one of which is referred to in the judgment. The first is a case called Bristow and Cormican, which is in Authorities Bundle 1, page 8248, tab 15. This is a decision of the House of Lords about title to Loch Ness in Northern Ireland, and the plaintiff sued fishermen for trespass for fishing in the loch. The fishermen disputed the plaintiff's title to sue in trespass. The trial judge held that the evidence of the plaintiff's title was so clear there was nothing for the jury to decide and withdrew the question of title from the jury. On appeal, it was held all the way up to the House of Lords, for that decision was wrong and the question of title should have been left to the jury. The plaintiffs had title deeds going as far back as a 1660 grant of a land by King Charles II, but the House of Lords said the title was not sufficiently clear to justify directing the jury to accept it. If I can begin with Lord Cairns's judgment at page 8258 at the top. Just to identify the question for the House of Lords in that case. Question for your Lordship's consideration is, was the course taken by the learned judge at the trial the right one, or was it not? In other words, was the learned judge, upon the documentary and other evidence before him, right in treating the title of the appellants to the fishery as a question of law to be withdrawn from the jury? And just to say, what's rather confusingly called a several fishery actually means title to the soil of a lake, which gives you the exclusive right to fish. Several fishery seems like a very inapt way of describing it, but that's what a several fishery is. And at the very bottom of the page, Lord Cairns, in the last paragraph, says actual physical or mechanical possession of a fishery, few more they had not, and as far as the evidence went, they never had. If they had had possession of this kind for however short a period, it would, as against a trespasser, have been sufficient, but they had none. They therefore proceeded upon their documentary or paper title. And then at page 8260, he discusses the documentary title. And if I can pick it up about halfway down the page with the word old leases, he says, old leases have always been considered to be admissible as being evidence of acts of ownership. I understand this to rest on the principle that when at a distant period as to which there is no more direct evidence available, you find a person claiming to be the owner of property and willing to make himself responsible as lessor for the title to it, and another person willing to agree to give rent for the property and to enter into a solemn engagement as tenant of it, admitting his landlord's title. These circumstances are of themselves admissible as evidence of the title. They are real transactions between man and man, not intelligible except on the footing of title, or at least an honest belief in title. The payment of rent under such a lease is a farther and additional fact also admissible as evidence on the same principle. So he's explaining there why a document of title can be regarded as evidence of title, because it gives rise to an inference of fact that the person who entered into the lease did in fact have the title they purported to have. Page 8267. In the judgment of Lord Blackburn now, the last paragraph on that page, he says the matter in controversy at the trial was whether the plaintiffs had made out such a possessory title to the fishing in that part of Loch Ness which lies near Fewmore as would entitle them to sue the defendants as trespassers for fishing there, actual possession of a locus in quo would have been not merely evidence of title, but actually a title against wrongdoers. But there was no evidence at all that the plaintiffs or anyone under whom they claimed had been in actual possession of this part of the loch or the fishings there at any period subsequent to 1661. And then on the facing page, in a very important passage, beginning at the first break of paragraph on page 8268, he says, "It was argued at your lordship's bar that an entry claiming title gives possession, what is commonly called constructive possession as against those who show no title. I think it does if the person entering shows title, that is a right of possession in himself or those under whom he claims. But I cannot agree that the possession which gives such an entry gives is like actual possession, itself a title, even against a wrongdoer." What I take to be the law on this subject is very well illustrated by the proceedings in ejectment, which were once real, though latterly they became a fiction. A lease was made by the person wishing to recover the land. At first it was a real lease to a real person. The lessee entered on part of the farm, and if his lessor had title, that entry put the lessee in possession of the whole farm and enabled him to maintain an action against anyone who ousted him. Afterwards, the person who sought to defend the possession was permitted to do so only on the terms that he should confess lease, entry, and ouster, and rely only on title. After this, the lease, entry, and ouster never took place in fact. If the argument of the appellants was right, the effect of confessing entry would have been to put the defendant on proving his title, but it was perfectly clear law that the plaintiff in ejectment could only recover on the strength of his own title, showing most clearly to my mind that the entry only gave possession if the party entering had title, but did not, like actual possession, give a title in itself, nor even afford evidence of a title. So if you have all sorts of documents going back to 1660, and you enter on land and say, this is my land, I own it, that doesn't give you possession, that doesn't give you title. You have to show that the person from whom you acquired your title themselves had possession. And just one other short paragraph, because it's referred to sometimes in later authorities, page 657 in the judgment of Lord Hatherley.
So, and what's the electronic page number, sorry?
Sorry, page 8264, I apologise. 8264.
64.
It says, at the top of the page, there can be no doubt whatever that mere possession is sufficient against a person invading that possession without himself having any title whatever, a mere stranger, that is to say, it is sufficient as against a wrongdoer. The slightest amount of possession would be sufficient to entitle the person who is so in possession or claims under those who have been or are in such possession to recover as against a mere trespasser. It's been decided undoubtedly with respect to old leases in particular, especially where rent has been paid under them, that those leases do amount to clear and distinct evidence of possession for the reasons which have already been assigned. And when one reads that against the backdrop of the other observations that I've shown the board, it's clear that what Lord Hatherley means by the slightest amount of possession is possession even for a short period of time. In other words, once you have taken possession, even if you haven't been in possession very long, you have sufficient possession to sue a wrongdoer for trespasser. And as Lord Blackburn said, that possession is not merely evidence of title, it is title itself. And one more case before we break, if I may, at tab 50 on volume 2, page 8831.
88, what, sorry?
8831. Tab 49, I should have said. Tab 49, page 8831. Lord, this was a case where somebody who'd been in possession for less than the limitation period claimed compensation on the compulsory acquisition of the land and succeeded in the Privy Council. And if I can take the board to the judgment of Lord Macnaghten at page 79.
And again, I'm sorry, the electronic page? It's
Page 8837. Please forgive me, my lord. Page 8837.
Thank you.
The third paragraph says the Supreme Court upheld the view of the Minister. The High Court reversed this decision and granted a mandamus requiring the Minister to cause a valuation to be made. The only question on this appeal was whether or not a prima facie case for compensation had been disclosed. On the part of the minister, it was contended that upon the plaintiff's own showing, Clissold was a mere trespasser without any estate or interest in the land. Their lordships are unable to agree with this contention. It cannot be disputed that a person in possession of land in the assumed character of owner, exercising peaceably the ordinary rights of ownership, has a perfectly good title against all the world but the rightful owner, and if the rightful owner does not come forward and assert his title by processes of law within the period prescribed by the provisions of the statute of limitation applicable to this case, his right is forever extinguished and the possessory owner acquires an absolute title. So well, those are the cases I wanted to go to by way of introduction to Ocean Estates and Pindar, which I will address, if I may, at 10:30 tomorrow.
We shall adjourn until then.